morning, everybody. It's again indeed a great pleasure to welcome all of you all to this e-seminar. The topic of the day is an important topic in the current situation, tribunalization and usurpation of the executive by the judiciary. Now on to Mr. J. Ravindran to welcome the speaker of the day.
Good morning, everybody. Before we start the demise of Honorable Justice A.R. Lakshmanan and his wife Meenakshi Ayati, who passed away recently, of Mr. A.R.L. Sundaresan, Senior Advocate and President of Madras Bar Association. Everybody know Justice A.R. Lakshmanan was a very humble, intellectual judge and a person who thinks about social reforms. We deeply condole his death and we convey our condolences to the family. And this meeting is dedicated to His Lordship Mr. Justice A.R. Lakshmanan. The topic of the day is tribunalization and usurpation by the executive of judicial functions, to be addressed by Mr. Neeraj Kishan Kaul, Senior Advocate and former Additional Solicitor General of India. Sir, I thank you for accepting our invite, sir. Mr. Neeraj Kishan Kaul was a reputed and renowned Senior Advocate who was also a judge of Delhi High Court for a short span, and he took a right decision by resigning so that the law community did not lose an eminent lawyer. Sir, I thank you for accepting it, right, sir. Please address the august guest, sir.
Sir, good evening. Good morning, sir. You're able to hear us, sir?
It's an honor to be invited by you and to share my thoughts on a very interesting subject with this very esteemed audience. And before I commence, let me convey my deepest condolences to the family of the late Justice Lakshmanan for this deep loss that has occurred. His commitment to rule of law, his contribution to jurisprudence is well known, apart from being a wonderful soul. And from the deepest bottom of our heart, we pray to God to give the departed soul peace of soul, and the strength to the family to bear this loss. Now, the subject that you have invited me to talk on is a subject of immense interest and debate across. And I think over the years, governments by a sleight of hand, through amendments, have tried everything possible, if you were to ask me, to usurp the jurisdiction of the courts. Article 50 of the Constitution very categorically provides and says separation of judiciary from the executive. State shall take steps to separate the judiciary from the executive in public services of the state. Now, initially the primary, and it's important to see the history, how it progressed. Initially, the primary reason attributed to the creation of these tribunals was overcoming crisis of delays, backlogs in the administration of justice, as highlighted in the 14th Law Commission of India Reform of Judicial Administration report. And the Law Commission then recommended a new system of tribunals at the center and state levels, empowered to deal with service cases of government servants relating to their constitutional rights, conditions of service, etc. But it is significant to remember that even then the 14th Law Commission specifically said that cautioned and said that the executive adjudication was only a supplementary role that the tribunal should take as opposed to supplanting the traditional courts. So it's important that even way back then, the 14th Law Commission report was cautioned, and it said that your role is not to supplant, your role is only to supplement. Now, what happened as we went along were a lot of socio-economic legislations also came along, and that further led to a debate on whether we should have Law Commission report, should we have tribunalization or not. Ultimately, during the emergency era, where various amendments were proposed, the new dimension was added, of course, based on the rationalization of speedy justice, overcrowding of courts, etc. But I think the real purpose of the government of the day was balancing the powers of the parliament and the executive and the judiciary, because there was a feeling that judiciary was overexerting itself. And it was at that stage that the Swaran Singh committee came to be appointed, which ultimately led to the 42nd amendment being passed. Now, the Swaran Singh committee report actually recommended the exclusion of jurisdiction of all courts in relation to tribunals, except for the Supreme Court under Article 136. It recommended limiting the High Court's writ jurisdiction, and really, if that recommendation was to be accepted in its toto, the High Courts would have lost their power to declare law unconstitutional, could not exercise any power of any kind over administrative action or adjudication unless fundamental rights were involved. That was the extent to which the Swaran Singh committee report went. After that, Parliament amended the Constitution by way of the 42nd Amendment Act 1976, which is known as the 42nd Amendment. And what was introduced was 323A and 323B2. Now, effectively, what 323A 2D did was to exclude jurisdiction of all courts except jurisdiction of Supreme Court under Article 136 with regard to disputes or complaints referred to in Clause 1 of the said article. And similarly was a provision in 323B2D. Therefore, although the official justification for the insertion of these provisions in the Constitution spoke of mounting arrears in high courts and the need of speedy disposal to service matters, it was by then, I think, apparent that the real purpose for adding impetus was to strengthen the government control at the expense of the judiciary that had stood up against the government of the day during the emergency era. And that really looked like the real intent behind this. Now, many amendments to the Constitution, which were made through the 42nd Amendment, were reversed by the Constitution 44th Amendment, and the High Court's power of superintendence over other tribunals under 227 was restored. No amendments were made to 323A or 323B as they then stood. And the courts continued, strictly speaking, to remain divested as controlled in those articles. Now, the first challenge which came to this, can you hear me, all of you? Yes. You can hear me, Ravindra?
Yes, sir, we can hear you,
Yes,
sir.
Yes, sir.
yes. So the first challenge which came to this was really SP Sampath Kumar. But SP Sampath Kumar really went on to hold that the writ jurisdiction of the High Court could be excluded with respect to disputes placed within the jurisdiction of administrative tribunals. And they qualified them as alternative institutional mechanisms. Now, the real chance after that which came was when, in the case of Sakinala Harinath versus the state of Andhra Pradesh, the High Court and the three-judge bench of the Andhra Pradesh High Court struck down the clauses 2D and 3D of Article 323A and 323B for violating the High Court's power of judicial review. Now, this gave a great opportunity to the Supreme Court, where a constitution bench was constituted of 7 judges, and L. Chandrakumar came to be decided in the year 1997. The two real questions which arose for consideration in L. Chandrakumar were, first was whether the provisions of Article 323A, 323B, allowing for the ouster of the entire jurisdiction of all courts except that of the Supreme Court under 136, ran counter to the High Court and Supreme Court's inviolable powers of judicial review under 226 and 32. And secondly, whether the tribunals being effective substitutes to the High Court's jurisdiction possess sufficient competence to invalidate statutory provisions and executive orders. Now, it's pertinent to remember that apart from the fact that the Apex Court rose to the occasion and struck down 323 and 323B, on both these questions, and resultantly held 2D and 3D respectively to be violating the basic structure of the Constitution, the court also went on to hold that no tribunal can abrogate the power of the High Courts or replace the High Courts in any manner, and could not take away the jurisdiction under 226 and 227. The L. Chandrakumar judgment, while ruling on this, took into account the data pertaining to the working of these tribunals for more than 5 years by then, and expressed anguish with the state of affairs which weighed heavily in the mind of the judges at that stage. It also concluded that the powers contained in 226 and Article 32 were part of the basic structure of the Constitution and could never be ousted through tribunalization. However, the court did provide a leeway to the executive by holding that nothing in the Constitution prescribed the creation of tribunals that supplement the high courts without substituting them. But I think it was still a marked departure from Sampath Kumar's decision, wherein tribunals were bodies which substitute courts. So with these decisions, the courts paved the way for transition of tribunals from an alternative institutional mechanism to one integrated within the judicial system and subject to the power of judicial review by high courts under Article 226 of the Constitution. It's important to remember one interesting observation made in L. Chandrakumar's matter, and I quote, "The tribunals are competent to hear matters where the vires of statutory provisions are questioned. However, in discharge of this duty, they cannot act as substitute for high courts and Supreme Court, which have under our Constitution set up, been specifically entrusted with such an obligation. Their function in this respect is only supplementary, and all such decisions of the tribunals will be subject to scrutiny before a division bench of the respective high courts." Now, despite the L. Chandrakumar judgment, the executive continued and the second wave of indiscriminate tribunalization continued. So while in the initial phase, the stress was more on the constitutional powers of judicial review being taken away, in the second wave of tribunalization, what was sought to be done was that several areas of jurisdiction of the courts were sought to be whittled down and transferred to statutorily created legislature of the state. So from securitization law, recovery tribunals, administrative tribunals, consumer forums, intellectual property tribunals, custom tribunals, etc. All these tribunals were created and all these jurisdictions which were under the statute vested in the courts were sought to be transferred to the tribunals. And the government of the day retained the power to appoint presiding officers for these fora. So hence quite distinct from the erstwhile issues which really related to judicial review and jurisdiction, the new age challenge concerned the institutional dangers that were a direct result of inroads made by the executive in the administration of these tribunals. This is when the second wave of tribunalization happened. And coupled with this came the concerns of dilution of judicial standards, since it was felt that members of the tribunals lacked the requisite judicial expertise to deal with matters which were till now dealt with by the high courts. A judgment in R. Gandhi gave another opportunity to the courts to look into these issues. And the division bench of the Madras High Court, R. Gandhi, struck down several provisions of the amendments pertaining to qualifications and appointment of members to the tribunal, as well as their conditions of service. The significance of this judgment, apart from being upheld in its entirety by the Supreme Court, lies in the fact that the High Court glossed over the constitutional silence emphasized by the Union of India to generate a set of minimal standards which any adjudicatory body had to satisfy, and these standards were affirmed and further modified by the Constitution Bench of the Supreme Court in its judgment of Union of India versus R. Gandhi. And some of the salient features of those safeguards as far as independence of members and minimum standards of judicial maintenance of judicial standards were: the chairman of the NCLT would be a retired judge of the High Court. All tribunals need not have technical members. The post of a judicial member can only be filled by advocates of a standing of 10 years or more at the bar, or district judges with experience of 5 years or more, and not with bureaucrats or those from Indian legal service. The post of a technical member can only be filled with those who are of the rank of secretary or additional secretary in Indian Company Law Service or Indian Legal Service. The qualifications possessed by technical members have to bear strong nexus with the functions of NCLT. The election committee for appointment of members to NCLT must consist of the Chief Justice or his nominee and another senior judge of the Supreme Court. Then the terms of office of members shall be for 7 years or 5 years, and they shall be eligible for reappointment for 1 term, etc., etc. The purpose being that maintain certain judicial standards and independence, because they are performing functions which are going to supplement the functions in a mechanism of what the courts perform. And there was a huge concern on dilution of these standards with the entire power vesting in the executive. And the emphasis was laid in this decision on the fact that 2-member benches of the tribunal should always have a judicial member. Whenever larger or special benches constituted, the number of technical members shall not exceed the judicial members there. The most important element in this overall emphasis given by the Supreme Court on the criteria for and manner of appointment of members, the qualification and conditions of service of such members, in evaluation of these criteria and on the anvil of judicial independence, specific functions carried out by the tribunals in question really stand out as the hallmarks of this judgment. Mr. Anand Padmanabham, in an article on copyright and constitutional infirmities, made some very pertinent observations and suggestions, and he said, and I quote him, that even where the transfer of jurisdiction to a tribunal was with respect to statutorily vested powers of the courts, it was necessitated that the tribunals ought to be composed of members of a rank, capacity, and status as equal as possible to the rank, status, and capacity of the court, which had hitherto dealt with such matters. And further, to order preserve its independence, the Supreme Court went on to hold in R. Gandhi that members of the tribunal should have independence and security of tenure associated with the courts. That was his comment, welcoming the suggestions made in the case of R. Gandhi. Now, it's interesting to note that despite these observations, the Supreme Court really didn't make any attempt to dissuade the executive from indulging itself of this self-assigned adjudicatory role. So there was always this role of supplementing the courts, and the executive every time used this leeway, as I see it, to take away vital and important powers of the court, which the Constitution had essentially vested in the courts, emphasizing on separation of powers. And Justice Ravindran, in fact, and with due respect to the learned judge, I do not agree with his views in the judgment, where he went on to justify it by saying that they were cost affordable and they were user-friendly manner to the tribunals. As later data and experience has revealed, neither are they cost effective, nor are they user-friendly, and have left much arrears, to costs being involved, to delays occurring, to adjournments happening on every account. If I were to be asked, according to me, tribunalization has been a failure in this country. Now then, the current scenario, as repeated inroads, continued. And despite all these directions, the executive continued to what it did. Ultimately came then the Madras Bar Association versus the Union of India, the 2014 decision. And the judges of, and the Supreme Court went on to hold, and the few of the directions which are important, I'll just highlight them, that members of the tribunal should be appointed in the same manner and should be entitled to the same security of tenure as judges of the court sought to be substituted. The court affirmed the position as laid down in Chandrakumar and R. Gandhi. And the court also observed that since some of the jurisdictions of the High Court was being transferred to the tribunals, the stature of the members, conditions of service, and manner of appointment, removal of manners must be akin to that of the judges of the High Court, and thus Section 7 was struck down in that matter. Also, Section 8 was held to be unconstitutional, and the court noted that NTT has been vested with jurisdiction that earlier vested in High Court. All matters of appointment and extension of tenure must be shielded from the executive. Now, thereafter came the decision of Madras Bar Association versus Union of India in 2015 dealing with NCLT and NCLAT. And again, an attempt was made by the government to now encroach upon the powers of the judiciary, although one had thought that there would be some restraint by previous judgments. But with the passage of the Finance Act of 2017, the government made another attempt at encroaching the domain of the judiciary in the guise of restructuring the tribunal structure in India. And the issues came to be recently dealt with by the Constitutional Bench of the Supreme Court in Roger Matthews versus South Bank India. It's a 2019 decision. The Supreme Court unanimously struck down the rules made under Section 184 of the Act, stating that the search and selection committee as formulated under the rules is an attempt to keep the judiciary away from the process of selection and appointment of members, vice chairman, chairman, and tribunals, and also went on to hold that there has been a blatant dilution of judicial character in appointments whereby candidates without judicial experience are prescribed to be eligible for adjudicatory posts such as that of presiding officers. And Justice Chandrachud, in a separate judgment on the issue, suggested that a National Tribunals Commission be set up to oversee the selection processes of members, criteria for appointment, salaries and allowances, introduction of common eligibility criteria for removal of chairpersons and members, so as also for meeting the requirements of infrastructural and financial resources. Now, some time back, Justice Rumapal, in a scathing review of the various judgments of the court over a period of time, criticized the Supreme Court as well, although the Supreme Court had retrieved the situation to a point after Sampath Kumar, but probably still gave a leeway for tribunalization, and the executive every time used it to usurp judicial functions. And the only sop was given was a 1 or 2 judicial members put on the fora concerned. But every attempt, with due respect, to pack them with bureaucrats was made and take away the judicial functions, which were essentially a function of the courts. And Justice Rumapal, while dealing with the whole issue, in an article, said that in a Kalidas-like action, it was like cutting the branch of the constitutional tree on which the judiciary is sitting, while criticizing the Supreme Court. And then went on to say that why or need, indeed how, having regard to the principle of separation of powers, can the power of adjudication be shared or be transferred to or be subject to the control of the executive, which is what tribunalization comes to mean in this country. And then she went on to make some interesting observations where she said that besides it would be too much to expect a government official who has represented and has been in some cases continues to be part of the executive machinery and who has been committed to give effect to the policies framed by his or her political masters throughout his or her career to suddenly be asked to discharge judicial functions, which often requires a decision to be taken against the government. Now, if speedy justice and backlog of cases and pressure on the courts was the answer, the clear solution is appoint judges on time. Don't delay appointment of judges. Have more courts. Have a greater representation of the judiciary. The answer is not to create tribunal after tribunal. And we are seeing what's happening with these tribunals as far as backlogs are concerned therein. Then an argument which was always sought to be given was, with socio-economic legislations, you need technical members who have expertise. And Justice Rumapal also dealt with it, and that's a view cutting across many scholars and experts and lawyers have had the feel, that you ultimately need a technical member as an expert for expert evidence and advice. You can always take it. Why must you have him in an adjudicatory role, which he is not trained for? Have him as a member, as an expert evidence, call for his advice. You can always do that. But why substitute judicial members or pack them with retired bureaucrats and in a way, with the sleight of hand, actually take away judicial functions and put them in the tribunals? Also, look at it from another angle. Every decision of the tribunal is subject to appeal before the High Court or the Supreme Court and subject to judicial review. So you further delay and add to expenses of litigants because of this additional round of litigation. Ultimately, looking at it, I am reminded, and there are 2 or 3 of my favorite quotes which I must cite to you before I move on. With regard to tribunalization, way back, late Justice Jaisimha Babu, judge of the Honorable Madras High Court in Gandhiya versus Union of India, had said, and I quote him, "Apprehensive that growing tribunalization of justice in the country, accompanied as it is by the executive aggrandizement of powers inter alia relating to composition, tenure of the tribunals, members and their selection, will result in the gradual erosion of judicial independence in the special areas for which tribunals are created and will ultimately lead to trivialization of justice." I'm also reminded of the famous lines of Alexander Hamilton in his Federalist Papers 78, which described judiciary as the least dangerous organ and gave a clarion call to the following effect. and I quote, and he said, "There is no liberty if the power of judging be not separated from the legislative and executive powers. And it proves in the last place that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments." The framers of the Constitution consciously created three organs and a separation of powers. And actually, with the way this tribunalization has been carried out and packing it with retired government officers and bureaucrats, you are actually diluting. You're actually diluting the separation of powers. You've actually already diluted to a great extent the separation of powers as it was envisaged, and you have usurped judicial functions, which was never the intent of the framers of the Constitution. And all kinds of justifications have been given for this. Justifications of backlog, justifications of speedy justice, justifications of easy access. And everyone who practices regularly in the tribunals, I do go occasionally, I don't get an opportunity now to go so often. But even when I used to go, and from all the young lawyers and other lawyers who go, that I hear from their experiences on each of these counts, which were used to justify tribunalizations, the tribunals have failed on each of these counts. In fact, if one were to look at it, on some of the cases, the 272nd report of the Law Commission came out with the pendency figures, and it said CAT had 44,000 cases, SET had 90,000 cases, ITAT had 90,000 cases, AFT had 10,000 cases pending. Then there were comments made. Another cause of delays, as was made out, was 58% failed hearings in tribunals. Another cause was absenteeism of tribunal members, which was done. The 74th Parliamentary Standing Committee report highlighted its concern over vacancies being a cause of the dysfunctional nature of tribunals. The report analyzed the list of 13 tribunals, wherein out of a sanctioned strength of 352 posts across these tribunals, 138 posts were lying vacant. Of course, someone could say that that's also a problem with the judicial appointments. Yes, it is. Judicial appointments should be made expeditiously. In fact, according to me, the day a learned judge demits office, his replacement should be ready to take over. There should not even be a day's delay. But the answer is not to fill up the courts and create tribunals. That's not the answer. The answer is to have more judges and more courts. But you can't keep packing the tribunals up, where also now delays are occurring in a major way. Also, there have been days when till recently, there have been some improvement now. NCLT didn't have members. They were working on alternate days. Members were traveling all over the country. Anyone who practices regularly in some of these tribunals in Delhi, and I'm sure in every other city would now, get into them, how difficult it is for a young and average lawyer to get passes made. So he rushes from a High Court or Supreme Court, reaches the tribunal, then stands in a queue, gets a pass made, then he enters, climbs 4 flights of stairs. Now, these are practical difficulties. It's very easy to say we've created tribunals, but this actually impedes access to justice, because access to justice also requires your lawyer to have easy access and to be readily available. Now, it's impossible for a person to just take one case and sit in a tribunal. That's not how the Indian system works. These are realities of life. What is the done? And with due respect, I have said that to this extent, I also blame the Supreme Court. I think they have given directions from time to time, even with regard to, for instance, in Delhi, for additional space being created across the Supreme Court in Pragati Maidan for offices of the court, for an auditorium. Very welcome. I think that was a great opportunity for the court also to direct that there should have been some land allotted where at least the principal 5-6 crucial tribunals could all have been consolidated at one place. It was a missed opportunity, according to me. And I think it's high time the courts and the executive woke up to the practical difficulties and impossibilities of a young lawyer, an average lawyer who does not have the benefit of conveyance, who is dependent on public transport, who does not have the benefit of drivers, to shuttle between tribunals, to shuttle from courts to tribunal, reach a court, get a pass made, had a hearing done. Even people with better off means, with cars, with drivers, chauffeurs, etc., have a problem. Now, if you don't have
Sir, I think you've got a internet connectivity problem, sir. Friends, a few seconds, I'll just connect to him.
He's trying to rejoin, Sneha.
Yeah. So in between, no, his bandwidth is showing very low.
No, I called him. He said that he's trying to rejoin another.
Okay. Friends, kindly bear with us. Sir's just trying to log in.
What exactly would I do that? Because I'm in love with you. Can you hear me?
Yes, sir. Yes, sir.
I'm so sorry I got disconnected. So
Sir, it's okay. Yes, sir.
how do people reach these tribunals? That's not the tribunals. Getting to courts is, at least in a city like Delhi, a nightmare. Why the person rushes between them. These are realities. And I'm reminded of the late Justice Krishna Iyer's article many years ago. He titled it as "Why Stultify Judges' Status?" And he said, creating deemed justices of high courts with equal status and salary suggests an oblique bypassing of the Constitution. And I think that is exactly what is happening here. And personally, if you ask me, on all parameters, I have said so again and again in various discussions, I think tribunals have been a failure. The solution lies in restoring the jurisdiction of the courts, getting more judges appointed, and tribunals, except for maybe a few fields, have failed to deliver on what they were required to deliver in this country. And I don't think this was ever the intent of the framers of the Constitution, that the form in which the courts have been divested of the powers vested in them of adjudicating in a cross section of subjects has now been vested in the tribunals. And all on the ground of speedy justice for the common man, easy access, less cost. And I think on all those fronts, it has failed. And to me, it'll always be a matter of concern that if a bureaucrat who has served for years and has only executed the policies of his master at every stage and the framed government policies, does he come with the necessary judicial training? Does he come with the necessary judicial expertise, which is so required as is required with every organ of the state? The executive requires a particular kind of training. That's not a job you and I can perform. The legislature requires a certain kind of experience in training. That's why people excel as parliamentarians. It takes years to excel as a parliamentarian. Similarly, you're trained from the first day as you join as a lawyer. Then you become a judge. You move up the ladder. Now, suddenly you have someone parachuted into it. Of course, a counter argument is made that a bureaucrat in his years also performs quasi-judicial functions in various districts. That's a completely different thing altogether. The kind of adjudicatory functions that we are today talking about, the kind of independence that we are today talking about, according to me, can only happen if tribunals were to be only manned by judicially trained lawyers and judges, if at all. According to me, we must go back to the stage, or at least largely go back to the stage of restoring the jurisdiction of the courts. That's essentially what I have to say, and I welcome any questions if someone has a question.
Sir, before anyone could ask a question, sir, we've got Justice M.V. Muralidharan from Manipur High Court to tell a hi to you, sir.
Yes. Where is
Sir, Muralidharan.
good afternoon, sir. How are you, Judge?
I'm fine. How are you?
Very well, Judge.
Yes. Yes.
So nice. What a pleasure to hear your voice.
Yes,
What a pleasure, Judge.
Yes, thank you, sir. Thank you. Really,
You,
I
Judge.
enjoyed today your speech.
I hope I didn't bore you, Judge.
Okay, thank you so much. Thank you, sir. Please, sir.
Thank you, Judge.
Sir, thank you. Sir, thank you so much. Thank you, sir. Neeraj, sir, we've got our senior counsel and former Advocate General of Madras High Court, Mr. Vidudalai.
Oh,
Yes.
Vidudalai, sir, you're able to hear me?
yes, sir. Mr. Vidudalai.
Yes, sir.
Good
Sir,
morning, Mr. Vidudalai. How are you?
Fine, sir. Thank you, sir. Thank you for the wonderful lecture. But what is still bugging in my mind is,
Sir.
if tribunalization is an affront to the theory of separation of powers, it should go in toto to the pre-1975 level. And any compromise by stuffing them with retired judges might not remove the unconstitutionality, seems to be my thought. What are your intakes on that, sir?
If you personally ask me, Mr. Vidudalai, I'm in complete agreement with you. When I said, if at all, I said that was to me a better alternative if tribunalization was to remain. I would then much rather have retired judges who are entirely appointed by the courts, not with the patronage of the executive. But if you were to ask me, according to me, I would. If my view is we should restore it back to the stage of the entire powers and jurisdiction with the court.
Oh, thank you, sir. Thank you, sir.
So I would agree with you.
Yes, sir. Justice Umapal seems to be more on the right track. I mean, that's what I was feeling.
Yes, it's an article which came out many years ago.
Yes.
And I think it was first reported in the Indian Express, if I'm not wrong. But I think it was widely reported. And I think personally, she was spot on. Because if you see, over a period of time, every possible conceivable attempt was made by the executive, by a sleight of hand or otherwise. And somehow I think the courts also kept giving them that leeway. Although they struck down certain articles as they did in L. Chandrakumar and later on many provisions as far as dilution of standard was concerned. But that leeway remained. And under the garb of that leeway of supplementing and not supplanting, they actually, what would they do? You would have one judicial member, two judicial members, pack it with bureaucrats, take away all jurisdictions. I don't think that was ever the intent of the framers of the Constitution.
So I must really thank you for the wonderful lecture, sir. It was really wonderful and all-inclusive, comprehensive, and thought-provoking. Thank you, sir.
I'm very, very grateful and lovely to see you and talk to you, Mr. Vidudalai.
Thank you. Thank you.
Neeraj, sir, we've got one Mr. Veera Kadiravan, yet another senior counsel from the Madurai Bar, sir.
Yes.
Veera Kadiravan, sir.
We are overwhelmingly, sir, we are overwhelmingly happy to hear your lecture on this issue. I am in fully agreement with you pertaining to the tribunalization of and the things and all. I have one thing is troubling my mind, sir. How do you feel? How do you feel about the ADR system? No, the alternative dispute redressal system is also hijacking the powers of the courts, like mediation center, our arbitration act. All the powers of the judiciary is gradually taken out in the guise of Arbitration Act as well as the Lok Adalat as well as the alternative dispute redressal systems. So is it a failure in handling the issue, or how do you look at that? Because the Lok Adalat...
Yes, Mr. Vedda, I'm hearing you. Yes.
I'm of the view that the ADR system, Lok Adalat, is not giving the correct judgments or justice to the parties. They are compromising, little bit compromising of their rights. The laws are compromised. Their statutory rights are compromised in all these forums, including Arbitration Act becomes a mockery of judiciary. All arbitrations are coming once again to High Court under the arbitration applications and arbitration cases. Once again, judiciary is burdened with all these 36 applications, Section 9 application also. How do you look at that, sir?
So, I think the ADR as an issue, these are thought-provoking ideas that, and it's legitimate thoughts that you forwarded for consideration and debate. But I think the ADR system can't be equated with tribunalization. Tribunalization is a complete imposition by the executive of usurpation. Arbitration, let's go one by one. You raised mediation, I'll go one by one. Arbitration, the world over, is recognized as a voluntary decision of two private parties or a government and a private party to go to arbitration. No one can be forced to go to arbitration. So as far as arbitration is concerned, the court is always there, but it's for you to what you opt for. Now, if within that system, a competent tribunals are created, personally, I don't think there's anything wrong with it, especially given the fact with the kind of load that we have. And if at all something had to be a substitute, I think it should be the arbitral tribunals. As far as the courts in turn being loaded are concerned, then the whole issue arises, should you powers to the court to interfere or not? But the overwhelming view of the High Court, Supreme Court, and internationally under the UNCITRAL model and debates all over the world has been that if you vested the power in a tribunal and you have put your faith in that tribunal, then judicial interference should be restricted. I think very often, frankly, if you ask me, despite these principles being laid down, Indian courts do tend to overstep and get into areas which repeatedly now the Supreme Court and High Court has said they should not get into when arbitral tribunals are concerned. But I would not go to the extent of saying that arbitrations have divested the courts of their jurisdiction, because it's a voluntary mechanism where there are two parties agree to submit to the jurisdiction of a tribunal. And I think that is where, given that they deal with commerce, trade, expeditious disposal, sanctity of contracts, I think the courts have said ultimately you have to put your faith in a tribunal, and the jurisdiction has been limited under Section 937, and then if at all a petition travels to the Supreme Court. As far as Lok Adalats are concerned, people have had great experiences, and some, as you said right, Mr. Veera, have not had good experiences. Now, Lok Adalat is again something, if parties want to go and mediate or complete something, yes, there may be improvements needed. There may be polishing of the system needed. As you said, there may be cases where statutory rights are being trampled upon. They need to be corrected. But I think mediation personally and Lok Adalats are a welcome step in the right direction, along with arbitration. But they may need fine-tuning. That I'm with you. There'll be problems, people are facing problems where their rights are trampled upon. That all I can understand. But I think they are, to me, still welcome developments. And especially arbitration is a major development which I welcome. I don't think they can be compared in any way to what the executive sought to do through the route of tribunalization.
Yes, sir. Thank you.
Thank you.
So thank you so much, sir. We've got one Mr. K.R. Shankaran from Coimbatore, sir.
Yes, I would. Yes.
Shankaran, sir.
Hello, sir. Very good afternoon. It is so encouraging for... Yes. Are you able to hear me?
Yes, Mr. Shankaran. Good afternoon. I can hear you.
Shankaran, sir, but then there is some disturbance in your net connectivity.
Yes.
Yes, sir. Yes, sir.
Yes, Mr. Shankaran. Yes.
Tell me, sir. Now I'm in far down Tamil Nadu.
Yes, I can hear you.
It is so encouraging to, it is so encouraging to hear your views on, abolition. I mean, according to me, there cannot be any via media. And when we are in the days of justice at doorstep, it is necessary that the courts are established everywhere and not, tribunals, which is definitely a usurpation of the judiciary. Thank you so much, sir. We fully endorse you with your views and views of Mr. Vidudale. Thank you, sir.
Thank you very much, Mr. Sankaran. Lovely hearing you.
Thank you.
Thank you, sir. Sir, we've got the last one, Mr. V. Vasanta Kumar, sir.
Yes.
Vasanta Kumar, sir, your...
Yes, sir. Good afternoon, sir.
Good afternoon, Mr. Vasant Kumar.
So it's a really enriching lecture, sir. What my thoughts have been just vouched by your lecture. And I completely and respectfully agree with your views with regard to tribunalisation. And my question would be, sir,
Yes.
from 2010, MPA 1 and R. Gandhi, recently Roger Matthew, Supreme Court consistently said that executive cannot affront with the appointments of the tribunal members. But still,
Yes.
the executive is framing rules accommodating the bureaucrats in the tribunals. Recently, the rules have been challenged before the Madras High Court and Supreme Court. My respectful question would be that why don't the Supreme Court so want to take cognizance of this contemptuous act of the government and reprimand the officers who are liable to frame these rules, which is against the judgment of Supreme Court, because way back 2010, Supreme Court said that tribunals cannot be manned by the executive, only by the lawyers and judges. But still,
Yes.
the executive framing rules. What is your thoughts? Because 129 of the Constitution empowers Supreme Court to take same out of cognizance of the contempt and punish the executive for violation of the judgments. I would like to know your thoughts on this aspect, sir.
Mr. Vasant Kumar, I, during the course of my talk, echoed the same view as you are so eloquently putting across, that despite repeated judgments of the court,
Yes, sir.
it started first with a judicial review usurpation, then it came down to taking away all the various fields of law statutorily vested in courts. Then it came to appointments of members to be appointed. At every stage and every form, by the sleight of hand, the executive has tried to violate the orders of the court or to introduce bureaucrats in violation of those orders and usurp functions of the court. The court has come down. The recent judgment, they have, according to me, observed very strongly and rightly so on these attempts. And I think in days to come, you're right, the court will possibly have to take even a more stronger view on this and say that this kind of a repeated violation of the mandate of the Supreme Court of India is completely unacceptable and impermissible.
Thank you for your thoughts, sir. And another question I would like to personally ask you, sir, with regard to that establishment of courts of appeal, because the framers of the Constitution thought the Supreme Court should entertain only SLP with regard to question of law and question of national importance. Of late, Supreme Court, after late 70s, the Supreme Court is trying all kind of SLPs. And the Constitutional Bench decided the question of law has come down because a book called Govind Goyal has catalogued all the judgments of Supreme Court, where Supreme Court has renewed a status of constitutional stature. Therefore, I have filed a request for the establishment of National Court of Appeal, where it may be sub judice, but I personally ask you because this cannot be discussed, but I would like to know your thoughts with regard to the courts of appeals.
So, even with regard to direct appeals with respect to tribunals which go straight to the Supreme Court, I'm just taking off from what you raised. Yes, there is a huge debate and criticism that these direct appeals to the Supreme Court, bypassing a high court, in a way does away with the three-tier system which was so consciously put in place. It also deprives in a lot of subjects and areas the judges of the high court and lawyers of that experience of dealing with those matters, because the appeals go straight to the Supreme Court. Ultimately, when a judge travels from the High Court to the Supreme Court, he's gained that experience in the High Court and then comes to the Supreme Court. So very often, or has practiced in the High Court, has dealt with these kind of matters. Now, not only are you doing away with one right of appeal or a fora which could have legitimately dealt with it, you're also depriving a whole section of lawyers and judges not to be exposed to that branch at all, with direct appeals being provided from the tribunal to the Supreme Court. Quite apart from that, when you said the Supreme Court is meant for questions of law, etc., of course you're right. And I think there's a overwhelming view now cutting across that large number of matters which are being today heard and decided by the Supreme Court are not the kind of matter which the Supreme Court should be at all engaged in. They are not meant to come to the Supreme Court. They are meant to be given a quietus to with the High Court. They must end with the High Court. And I think a lot of those matters is not what the Supreme Court should be engaged in. You're absolutely right there.
Thank you. Thank you very much, sir.
Thank you.
Thank you.
Thank you.
So
It's a great pleasure. Great pleasure to have shared my thoughts with all of you and heard all of you.
So, if you don't mind, sir, so there's one Mr. P. Dinesh Kumar who has raised his hand, sir.
Yes, yes, please. I'm very happy.
Dinesh Kumar. So I'm not able to. Sir, he's not here. I think some connectivity problem. So thank you so much, sir, for having spent your valuable time here with us. And in a very brief, short thing, you have really brought out the more than the pros, the cons of the tribunalization of an assumption of the executive by judiciary. So thank you so much, sir.
Thank you. Thank you so much of talking to all of you. Such a pleasure always to talk to all of you, and very kind of you to have invited me.
Thank you so much, sir. Thank you.
Thank you. God bless.